Good afternoon, everybody, and thank you for attending our housing seminar. Prynhawn a chroeso I chi gyd. I'm Nigel Hollett, the director of the CLA in Wales, and for those of you who are members, you will know that we represent a wide range of rural and farm-based businesses across England and Wales, with around 28,000 members. In Wales, housing is a major issue and a major area of interest to us all. You know, from the agenda that includes affordable homes, holiday lets and accommodation, improving energy efficiency and second homes. But this session is particularly going to focus on the changes to housing policy and legislation this year. So without further ado, if we can make a formal start. You've all had a copy of the agenda. We have speakers who are going to tell you a little bit more about what we are expecting this year, and then we'll have plenty of opportunity at the end for question and answer session. So our speakers are Simon White, Head of Housing Legislation at Welsh Government, Richard Corbett, who is a partner at Roger Parry Land Agents, Helen Shipsey, who's our Senior Legal Advisor in the CLA, and last but certainly not least, Emily Church, our Policy and Engagement Advisor from the CLA in Wales. So Simon, before I hand over to you, you, according to your biography, have held a variety of public service roles in the voluntary sector, UK government, European Union, and since 2010, the Welsh Government. You're currently Head of Housing Legislation, which includes responsibility for the implementation of the Rent in Homes Wales Act 2016. As recently amended to improve security of tenure. I know, Simon, that your team leads on leasehold reform and the emergency legislation introduced in Wales to protect renters during the coronavirus pandemic. Simon, without further ado, I will hand over to you. Diolch yn fawr. And you're on mute, Simon. Simon, sorry, you're on mute.
Got everything else lined up for the presentation to share.
Not to worry, don't worry.
Okay, anyway, sorry. Good afternoon, everyone. Nice to be here. Thank you for the invitation, Nigel, and good to be working with you again today. So I'm going to give you a quick talk through the Renting Homes Act. I'm hoping some of you will have seen some information on it. I'll try and get through the slides as quickly as possible. There's a fair bit of information here, but obviously I'll share the slides with Emily and the team so that they can share them with you afterwards as well. So that's me. I'm Head of Housing Legislation in the Welsh Government. Worked on renting homes for quite some time. Those are contact details if you want to get in touch. A very quick summary of the Act. It's based on recommendations from the Law Commission, which is the body responsible for keeping the law of England and Wales up to date, if you like. And we amended it last year to increase security of tenure. And we decided to amend the 2016 Act before we implemented it, so that we won't bringing another change very swiftly on top of the previous one. So what will the Act do? It will create a single legal framework for social and private renting. Key point really is to get much better clarity on rights and responsibilities of both tenants and landlords through having written contracts that have all of those rights and responsibilities set out within them. There will be model contracts that are freely available now for landlords to start looking at and drawing up. And there are two types of contracts. There's the secure contract, which will replace secure tenancies, assured tenancies. They are the default for local authorities and housing associations, but they can be used by private landlords. And then there's the standard contract, which is kind of similar to the current assured short-hold tenancy, if you like. So lower level of security, but you can agree fixed terms to give greater security. And there's also a legal basis for supported housing, but I won't say dwell on that today. Some key features of the 2016 Act then, it introduces a fitness for human habitation obligation on landlords. I say introduce, some of you who've been in the game for a long time may remember fitness is something that used to apply quite some time ago. So it's reintroducing that general fitness obligation across all contracts. It addresses retaliatory eviction, which you still hear of occasionally, where a tenant complains about the boiler being broken and the landlord issues an eviction notice the next day. So it does address that. More flexible arrangements for joint contracts, which I think should be generally seen as a positive. So can allow you to add and subtract tenants to the contract without having to stop one contract and start another. The notice period for a rent increase goes up from 1 month to 2 months. There's no mandatory ground for eviction for serious rent arrears in the secure contract, but it does remain pretty much as it is at the moment for ASTs in the standard contract. There are enhanced succession rights, which will apply both to the secure and the standard contract. Of course, succession rights apply to ASTs at the moment. They probably don't get much coverage in relation to ASTs because you have you can end the contract if you're not happy with the succession that takes place. That is the same under renting homes. There's a simplified procedure to repossess abandoned dwellings. So when a tenant has deserted the property, at the moment, landlords will often have to end possession notice and go to court. That can take many months to get possession back securely. Under this process, under renting homes, it's basically a 4-week notice, and then you can take back possession of an abandoned dwelling. And there's also a 10 years, as I said, specific to supported accommodation. So the Act was amended last year through the Amendment Act. That now, so that basically set the no-fault notice period at 6 months. So many of you will be aware of the current Section 21 2-month no-fault notice arrangement. Whereas Scotland, they totally abolished their equivalent of the Section 21 notice in their recent changes. England's talking about abolishing the Section 21 notice. We came at this from a different route, and we said actually the key point is not it is the length of time that someone who is not at fault has to find somewhere else to live. So we decided to keep the no fault notice, but to set the notice period at 6 months. So it's a different approach that we're taking in Wales. We've also got a restriction on issuing that 6 months notice within the first 6 months. So effectively, you've got a minimum 1 year tenure if the tenant's not at fault. There's a 6-month restriction if there is a retaliatory eviction. We can probably have some questions about retaliatory eviction later on, no doubt. But basically, if the court finds there was a retaliatory eviction attempted, then there's a further 6-month restriction on issuing another notice. We've removed the ability to end a fixed term standard contract in the same way that you currently end a fixed term AST. We did that basically to allow fixed terms to still operate. So again, in Scotland, they've abolished fixed terms. We decided, no, there is a place for fixed terms, but we needed to amend how you end a fixed term so that it can't be used to sort of undermine the broader security of tenure policy that we're pursuing through this. And similarly, some restriction on use of break clauses in contracts. I don't think break clauses get used a great deal, but basically you can't have a break clause in a contract of less than a fixed term of less than 2 years. Some key concepts in the legislation. We talk about occupation contracts. We do that because anyone who rents a home at the moment in Wales does so under either a tenancy or a license. That will still be the case under renting homes. But if you rent a home, in return, you pay rent, you occupy the dwelling as a home, it will be an occupation contract. And I've said there's 2 types of contract. There's the secure contract, which is periodic, so week to week, month to month. And then there's the standard contract, which can be periodic or fixed term. A couple of other key concepts in terms of landlords. There are just 2 types of landlords. There's what we call community landlords, which is local authorities and housing associations, and everybody else is a private landlord under the legislation. So Welsh Government would be a private landlord if we bought a property in advance of a road scheme being developed and rented out. We would be doing so as a private landlord. The other sort of default arrangement is if you're a community landlord and you let someone move into your house and you don't do anything else, they'll have a secure contract. If you're a private landlord, the same happens. It's a standard contract. So the same arrangement as under the 88 Act, the default is it's a standard contract. And then we have this concept of a written statement, which can be a bit confusing. Essentially, it replaces the written tenancy agreement. So just as at the moment, you can start off the contract verbally. So you meet someone, you've got an empty property, you say, yeah, you can go and move in there tonight. That can all start off as a verbal contract. But unlike ASTs, within 14 days of the person moving in, you have to issue a written statement of the contract. So, and that date that someone moves in, we call the occupation date. So I know all of you, I'm sure, are issuing contracts before people move into the property. But if you don't issue it within 14 days of the occupation date, then the tenant can start withholding rent, a day's rent, up to 2 months until they get that contract. And that the reason that's there is because, going back to the Law Commission's original emphasis of making sure everyone is clear on their rights and responsibilities, we want to make sure everyone gets that written statement of their contract. So there are some sort of penalties if the written statement isn't issued or it's incorrect, and if an application goes to the court and the court is satisfied that the landlord was sort of willfully avoiding issuing the statement or an incorrect statement, then there are penalties that can be applied. There are 4 types of term in the contract. There are fundamental terms. Those are basically the legal minimum. There are supplementary terms, which are sort of more day-to-day things around managing the tenancy. So the fundamental term would be things like the landlord's repairing obligations, the notice period that you've got to give to end the contract. Supplementary terms would be things like the tenant needing to notify you if they're going to be away from the property for more than 4 weeks. Key matters are name and address of the parties, the address of the property, the amount of rent, and then additional terms is just anything else, such as a pets clause or something like that. Anything else that you agree with the contract holder that's going in the contract. The final terms will depend on whether it's a secure contract or a periodic standard or a fixed term standard, but actually probably 90% of the terms are consistent across those 3. And that's important because whereas at the moment, someone moving from private landlord to private landlord will essentially be faced with a totally different looking contract. In future, everyone will be getting something that looks much more similar, and therefore people will get a better understanding of those responsibilities that come with renting. So the terms of the contract can be varied, but not all in the same way. So fundamental terms, some of them can't be varied at all. So things like the antisocial behaviour term, that's got to be as it's provided in the model contract. But you can vary other fundamental terms to benefit the contract holder. And that's because the fundamental terms are the legal minimum. So you could agree that you're going to give 8 months notice for a no-fault notice, but you can't give less than 6 months. So it's the legal minimum, just as the sort of the 1988 Act sets out the legal minimum at the moment. Supplementary terms can be varied either way with the agreement of the contract holder. So either to benefit the landlord or to benefit the contract holder. And we've set out the model written statements. Hopefully you've had a chance to look at those. They're available on the website if you haven't. Fitness for human habitation, I've said that's basically, it hangs off of the 29 hazards that are under the Housing Health and Safety Rating System, which you're probably familiar with. So there's those 29 hazards, but we've also set some specific requirements. There are 3 specific requirements. You have to have an electrical safety test at least every 5 years. You have to have hardwired smoke detectors, and you have to have a carbon monoxide detector. The carbon monoxide detector doesn't have to be hardwired. And there's a 12-month grace period on the electrical safety testing and the hardwired smoke detectors for converted contracts. Termination, so ending a contract, essentially for all contracts, if the contract has been breached, the landlord can apply for a breach of contract possession order. That's a discretionary ground, and the court has to take certain things into account in terms of reasonableness. But that's probably going to be one of the main grounds you might look to use as the breach of contract ground. There are then estate management grounds, which deal with things like sort of if you've got to refurbish the property, you need to move someone out temporarily, those sorts of things. That might be relevant to some of you. And then For other contracts, for the secure contract, basically, this also applies to the standard contract. If the contract holder gives notice that they're going to leave, but they don't leave on the date that they said they were going to leave, you can then apply to court for a mandatory possession order. And that's, they said, that's absolute ground, it's mandatory. So that applies, as I said, to the standard contract, but also to the periodic standard contract. You have the no fault notice. So it's under section 173, but it's similar to section 21 in terms of it being no fault, but there's a 6-month notice period unless it's a particular type of contract. So some of you might have a service occupancy, so where someone's occupying the accommodation as part of their employment contract. That's not subject to the 6-month notice, that's subject to the 2-month notice. So some types of contract aren't subject to the 6 months, but the standard is 6 months. And you can't give that notice during the first 6 months, but again, there are exceptions, such as a service occupancy. And as with section 21s, there are some restrictions on serving it. For example, if you haven't protected the tenancy deposit, but also if you haven't issued the written statement of the contract and others such as EPC certificates as well. But if you've complied with all the requirements around issuing the notice, it is a mandatory ground, but there is this retaliatory eviction protection. So if the way this works, essentially, if the tenant is able to provide evidence to the court that satisfies the court that the landlord was acting in a retaliatory manner. So, say, tenant complains about the broken boiler one day, the landlord issues an eviction notice the next day, no other prior evidence of looking to evict. The court might well decide that that was a retaliatory eviction. And what that does is it switches off the mandatory nature of the section 173 notice. So essentially what we're trying to do there is sort of, any landlord that might be tempted to think, I'm not going to repair the boiler, I'm going to get someone in who's going to cause less trouble. This is not the way to do it. You can't do it through a section 173 notice. And then, as I said, within the periodic standard contract, there is still the serious rent arrears ground, which is the sort of 8 weeks, 2 months, as it is at the moment. And that is a mandatory ground, an absolute ground. So the court has to make the possession order if the ground is made out. Fixed term standard contracts, as I said earlier, they can't generally be terminated by a notice in the same way as they can at the moment during the fixed term. You can't serve the notice during the fixed term unless it's something like a service occupancy. Again, there are exceptions. So if the person doesn't leave at the end of the agreed fixed term and it rolls over and becomes periodic, then the landlord would need to issue the 6-month notice. So there are options there. So you could decide if you're currently issuing 1-year fixed terms as standard, and you want to get certainty of possession back after that 1 year, you might in future decide to issue a 6-month fixed term and then issue the 6-month notice. So that behaviours might change around that. As I said, essentially, we wanted to make sure that people had a minimum of 1 year occupation if they weren't breaching their contract. So there is the possibility of landlord's break clauses, but they can only be included generally in contracts of 2 years or more. And the serious rent arrears is virtually identical to the periodic standard contract. Abandonment, so this is where if the landlord thinks that the property has been abandoned, the tenant can give notice, the landlord can give notice saying they think it's been abandoned. That can be served at the property or sent to an address that the landlord has. They must make inquiries to satisfy themselves it's still been abandoned. If after 4 weeks they're still satisfied that's the case, they can issue a notice that ends the contract at that point and they get back possession after that 4-week period. There have to be some protections, obviously, to make sure that's not abused. So if within 6 months of recovery of possession, the contract holder wants to contest it, they can apply to the court, and the court can make any order it thinks fit if they think the landlord didn't serve the notice properly, for example. Joint contracts, as I said, there'll be more flexibility around joint contracts. So you can add and subtract tenants That will hopefully make life easier if you've got a change of tenant situation. For model contracts, as I said, we understand it's quite sort of difficult to make sure you pull all of the relevant fundamental and supplementary terms together that you need to for the type of contract. So we've done that in the model contracts. So there's a model contract for the periodic standard, a model for the fixed term standard contract. They're available on the website. You can produce your own versions if you want, but they're going to look a lot like the models because they've got to include the same information essentially. So you're probably aware we're implementing on the 15th of July. Model written statements are available. Existing tenancies will convert. That's a key point. So an existing AST, a periodic AST will convert to a periodic standard contract. Fixed term AST will convert to a fixed term standard contract. For converted contracts, the written statement has to be issued within 6 months. So new tenancies after 15th of July, written statement within 14 days, converted contracts, 6 months. So we've laid quite a few regulations in the last couple of months. So they're all available on our website, the model written statements themselves, the fitness for human habitation regulations, guidance around that. We've made regulations regarding prescribed forms that you need to use if you're going to issue a possession notice, for example. Deposit schemes are going to work in exactly the same way, really. But we've had to issue the same prescribed information under our renting homes arrangements, but they're available, as is the safeguarding property and abandoned dwellings. So that safeguarding property is if there's personal possessions left after an abandonment, what you do with that. So they've got some more regulations coming in June, which are basically going to be referring to assured agricultural occupancies, housing associations, secure tenancies, and long tenancies. Some of these more obscure tenancy types, how they will convert, and also some amendments to some schedules. Those are mostly around definitions relating to asylum seeker accommodation and bail hostel accommodation. That's a list of the guidance that we've issued. We've got further guidance coming in May on including plain language guides to the standard and the secure contracts. Okay, I hope that's slightly over my allotted time, but as I said, hopefully that's enough to give you a good flavour of the information. I'll stop sharing my screen and hand over back to you, Chair.
Thank you very much, Simon. That's very helpful. We have actually got a couple of questions that have just come in, but Simon, you'll be pleased to know I'll give you a bit of time to think about your answers to those. So we'll do all the Q&A at the end. If anybody is submitting a question, if you could put it in the Q&A, that would be fantastic. But obviously we've got two already from David Lewis and Ian Howell, and we will pick those up at the end. So thank you very much, both of you. So if I can now move on to you, Richard. Richard, apparently your formative years were spent growing up on the local family farm. You joined Roger Parry and Partners in 2003, graduating from Harper Adams University with a degree in rural enterprise and land management. You're a member of RICS and a fellow of the CAAV. And in 2011, you became a partner in Roger Parry and Partners LLP. I think your experience is very significant, Richard, but I'm just pulling out some of the things there. You're involved in agricultural and estate management matters, valuations, entitlements, quotas, tenant issues, and probably everything else that gets thrown at you. So, Richard, without further ado, I'll hand over to you. Thank you very much.
Thank you very much. I'll just sort out the screen share quickly. So thank you very much, and good afternoon to you all. It's a very pleasure to get to speak to you all. I'm sure, as myself, as an agent advising people and a landlord myself, that it does seem a never-ending barrage of new legislation and rules that we need to follow within the private rental sector. And as Simon says, this does, on a positive note, appear to bring it all into one place, but it does come with further responsibilities that are quite significant to us within the private rental sector, whether that's the people with a couple of rental properties or substantial estates with lots of properties on. So I think the key questions, I think Emily asked me to speak really, and I've tried to pick out from what Simon said, really, what are the concerns for us as landlords? And I think the first sort of question, and what we all need to explore, is what will happen to our existing tenancies after the 15th of July? And will I have to issue a new contract within a certain time frame? What if I don't issue a new contract? And I think Simon has covered the point, but it will look like our tenant will have a right to remain for 12 months, which is a 6 months initial term, and then 6 months notice thereafter. And I think as a result of the COVID regulations ending, the notice period for an AST is temporarily reverted back to 2 months after it's been 6 months for quite a period for landlords. But I think the one thing I need to make you all aware, and you know what we're having discussions with our client, is that you only have a short period now in which to serve notice should you wish. We understand at this stage that as at the 15th of July, the notice period will automatically extend to 6 months. So if you have any pressing demands for housing on your estate, or things need to change, there is a very short window in which it's possible for you to do things at a practical level. That's not to avoid the guidance, Simon. It's just, you know, estates and landowners have opportunities or circumstances that they need to address. So I think the improvements required, I think Simon mentioned these, are fixed electrical smoke alarms, carbon monoxide alarms for all new lets from the 15th of July 2022. Section 104 deals with a variation in rent. Again, this is a massive change for agents, landlords. Rent increases can only be undertaken once a year after the 15th of July 2022, unless the tenants agree to renew the tenancy. So I think just going into the section in a bit more detail, it states that the landlord may vary the rent payable under a contract by giving the contract holder a notice setting out the new rent to take effect on the date specified in the notice. The period between the day on which the notice is given to the contract holder and the specified date may be no less than 2 months. And subject to that, the first notice may specify any date, and subsequent notices must specify a date which is not less than 1 year after the last date on which the new rent took effect. So that's 2 months notice, and then a full year from when the new rent took effect. So that's a 14-month period. So that's quite a fundamental change and a management process that we need to consider. With regards, just moving back to the concerns and responsibilities of landlords under the fitness for human habitation. So the crowding in space, a lack of adequate space for living and sleeping, is detailed within the legislation. So I think as landlords, we need to ensure that the tenants we're putting in are suitable for the property when they are being put within. For domestic hygiene, pest and refuge, point 15, so poor design, layout or construction that the dwelling cannot be readily kept clean, exposure to pests, and inadequate provision for the hygienic storage and disposal of household waste, and adequacy of kitchen facilities. Food safety 16, and inadequate provision of facilities for storage, preparation and cooking of food. Again, how adequate is the kitchen and its facilities? These are, again, things that we haven't had to consider to the same level. We've always tried to provide properties that are fit for human habitation, but I think the guidance takes this all a step further and quite clearly sets out what those tests will be. So again, succession rights, I think that's one thing that it was very, you know, we're wary of within the Act. For those of you that have been involved in sort of estate management, you will be aware of succession rights and the AHA tenancies, and we certainly hope, and from reading the guidance, we don't expect them to be like that, but they do. The Act does allow for succession for contract holders under an occupational contract. So the Act creates a new set of standards for properties to be habitable and free from serious defects. So the Act states a general obligation on all landlords to ensure that the dwelling is fit for human habitation at the start of the contract and throughout the time the contract is operational. which is under section 91 of the Act. There is an obligation on landlords to keep the structure and exterior in repair and keep installations for supply of water, gas and electricity, for sanitation, for space heating and hot water in repair and proper working order. The landlord must also make good any repair required by sections 91 and 92 of the Act. There does seem to be, as Simon has set out in his presentation, but as landlords, we need to provide a habitable and good environment for our tenants. And I think the regulations really hit home on that. And, the retaliatory evictions, support that further, that, there's teeth to this legislation. And furthermore, I know I was replying on what Simon said, but I think the Act cannot be looked alone in isolation, because we also have a minimum energy standards, efficiency standards in England and Wales that already require all private rented buildings, both residential and commercial, to have a minimum EPC rating of an E, which is certain to subject exceptions. But the recent government announcement of a minimum EPC C rating for new residential tenancies from 2025 and all residential tenancies from 2028 is a major concern, especially for many rural properties that may struggle to meet the current minimum energy efficiency standards, let alone a C rating. The costs of improving the properties are a real concern to the industry, both through the regulations and through the minimum energy efficiency standards. Nigel, that's really my commentary on the regulations, and I'd be quite happy to invite questions from the attendees.
That's brilliant. Thank you, Richard. We will come to you shortly. So just a reminder to everybody, do post your questions if you can in the Q&A button. If you can't find it, we will pick it up on the chat, but if you can do that, would be absolutely fantastic. So I'm now going to hand over to Helen Shipsey. Helen is from the CLA, our senior legal advisor. Helen, you trained at the bar. You've been part of the legal team at the CLA for over 20 years. I think it's fair to say you've advised on probably pretty much everything that we do within the organisation, but particularly around residential tenancies, but largely focusing now on agricultural tenancies and the letting of rural land generally. You sit on the Tenancy Reform Industry Group for the agricultural tenancy sector, and you're going to tell us a bit more about our guidelines, Helen, and what support we're offering to members. So over to you.
Thank you, Nigel. Yes, I'm just going to share my screen now, and hopefully you can all hear me.
Perfect.
Right. Good afternoon. It's a hard act to follow the previous two presentations. For my slot, I've tried to.
Helen, do you want to go onto the slideshow, because I think it might be a little bit bigger then for everybody to see, if that's okay. You can. If
Does it not work like that? You're not seeing.
Just put it on. It looks great, but if you could put it onto the slideshow, if that's possible, that would help.
It is saying it's on slideshow. No, that's.
Don't worry, we'll get there.
Not sure what I'm supposed to do.
Don't worry, just go with, I think, what you've got then, Helen.
I'm sorry.
Don't worry at all.
Okay. So for my allocated time, I've tried to develop some aspects of the legislation that have received less attention to date, but may be of particular interest to our members. And I apologise if there is some repetition, but I hope you'll bear with me. As Nigel said, I've been a part of the CLA legal team for over 20 years and advised on many subjects over that time. I've seen the growing bank of regulation that has developed in respect to the private rented sector. And there's much to welcome in this new approach developed on the work of the Law Commission some over 15 years ago now. Looking at this from England, where it's likely there will be a different approach shortly, there is reason to hope that the Welsh Government has struck a working balance here between the parties' interests. But what will be essential as to whether this works well or not is the civil justice framework underpinning the legislation. So in order to support members to adjust to this new terminology in legislation, I've prepared some guidance notes which are now available on the CLA website. The Welsh Government has already compiled a very helpful library of guidance and forms and model contracts, which I recommend to everyone. And it's also worth considering taking professional advice at this point in order to get all your agreements in line with the new legislation. It's a complex process to take on board all aspects of new legislation, particularly in the early stages where there's limited commentary available inevitably. So I'm not going to dwell on all the aspects that have been set out so clearly already. I'm just going to pick out certain elements. For instance, we know that all residential tenancies and licenses convert with limited exceptions. It stipulates in the Act that where there is an agreement to occupy a dwelling as a home and rent or other consideration is payable under it, then it will be an occupation contract. This may be an important issue for some of our members who accommodate employees. It's generally quite difficult to set up a genuine license for residential purposes, but one way is to grant a service occupancy, where it is stipulated that the employee is being accommodated for the better performance of their duties and no rent is charged. Is it envisaged that the employer-employee relationship here does equate to consideration, such as the standard situation where a housekeeper is accommodated in separate accommodation and charged no rent? The Act does deal specifically with service occupancies and give special rules for them, but it may require further guidance as to how they fit in if no rent is being charged. There are also special rules now in place of agricultural workers, but in recent years it would only be an employer who hasn't taken advice who would grant an agricultural employee an assured agricultural occupancy. Rather, in the way assured and assured short-hold tenancies were set up in the outset until the changes brought about in 1996. An employer now will serve a notice on the agricultural worker and then set up an assured short-hold tenancy with the minimum amount of rent being payable. I note that the Welsh Government is intending to produce further information on assured agricultural occupancies, which we await with interest. And it may be thought that there should no longer be the default that security is granted, and it should only be where both parties decide that that is appropriate. So we know that all the relevant tenancies are converting on the 15th of July, but there will be still some distinctions between the old and new, particularly in how possession can be recovered. So for converted assured short-hold periodic contracts, rather than the new 6 months notice, it will be 2, following on from 4 months occupation rather than 6. But contracts that were assured tenancies before will not have that as an option, with limited grounds for regaining possession, as it would have been under the Housing Act. There does appear to be a window for a landlord to serve a notice in the first 2 months of the new regime, determining that the contract is to be a standard contract rather than a secure contract, but this can be challenged by the contract holder. It may be that there's more guidance to follow on this, and if there are any instances where it would be relevant to private landlords, but given the short time frame, it's something that needs to be addressed as soon as possible. So it's going to be important to download the guidance, the new model contract now, to see how you can convert your existing contract and ensure that the terms are compatible with the new legislation. It's not going to be possible to vary terms except for rent until the written terms are given to the contract holder. And as we've heard, there are going to be penalties if you don't comply within time, such as delaying the point at which you can serve a notice for possession, and possibly compensation being payable. It's also going to be very important to keep a record of how and when the written terms are sent, and it can be in electronic form if the recipient is willing to accept it in that fashion. Just looking, we're also, as it's being flagged up, the fitness for human habitation standards, enhancing standards required, but there's going to be extra time for the electrical petition report and the smoke alarms, but for carbon monoxide alarms, you need to have them fitted by 15th of July 2022. So just flagging up here some differences that are in the two different regimes from before and after. They're not going to be the maximum and minimum limits for rents and licenses that we're used to, but there may be some discussion as what does amount to consideration. There's not going to be that requirement that the property be the occupant's only or principal home. From now on, it's going to be the right to occupy a dwelling as a home. Also, something to watch out for is that where a landlord lives in one dwelling and lets out another in the same converted building, that's going to be an occupation contract, whereas previously it wouldn't have been an assured short-term tenancy. There's still the shared accommodation exception where the landlord rents out accommodation in the building they live in, and they can give a notice to the occupier saying that the agreement is an occupation contract, but otherwise it isn't. And there's the same possibility with holiday accommodation as well. So as we've heard, there's now going to be the possibility of up to 2 rights of succession and the ability to remove one of joint tenants without bringing the original tenancy to an end, which is a very convenient, useful measure. There's going to be easier process in the event of abandonment, and we're going to have the longer new restrictions on regaining possession, longer notice periods. But there's still going to be that distinction, I know, between tenancy and licenses, albeit that they both might become occupation contracts. And there's a specific reference in the statute that where the occupation is a license based on the granting of a personal interest to occupy a dwelling by a landlord, it will end on the death of the landlord. That's just something to bear in mind, that they're not just going to merge together, that there may be still distinctions as when you're drafting documents. So looking at succession rights now. So there's going to be, as we say, 2 possible successions on the death of a sole contract holder. Firstly, if there's a priority successor, a spouse, partner, or cohabitee occupying the dwelling as their only or principal home at the time of the contract holder's death. Then if the priority successor dies or there isn't one, you look to the reserve successor, and that could be a family member who occupied the dwelling as their only home at the time of the contract holder's death. And if there's, other than the spouse, there's an extra basic residence requirement that of the period of 12 months ending with the contract holder's death, he or she occupied the dwelling or lived with the contract holder. And then there's a second category of reserve successor, the carer. There's a carer condition and a carer residence condition. But here we're talking about someone who's living with the contract holder and providing care to the contract holder or a member of the contract holder's family and living with the contract holder, and has no other dwelling which they're entitled to occupy as a home. And this is a person who is providing or intending to provide a substantial amount of care on a regular basis, but not because of a contract of employment. So just thought it worth flagging up here. It's worth noting a lot of the guidance at the moment is directed to private landlords, is assuming that they'll be dealing with standard contracts, short holds converting. And of course, there are private landlords with existing assured tenancies, and for our members in particular, they'll have assured agricultural occupancies in place. So just need to be alert, and we understand that there is more guidance coming through, which will be helpful to understand better whether these will automatically convert to secure contracts. Here, I'm just drawing attention to the fact that if or when it comes to the point where you want to recover possession of a property, you need to identify what type of agreement you are dealing with in order to ascertain which form you need and which regulations, etc., you need to comply with. And the Welsh Government website is really useful there, a comprehensive set of guidance and the forms set out, but you need to be able to identify, and just bear in mind there are these different categories of agreement. So along with the ability to recover possession at a shorter time frame for serious rent arrears, as we've heard, 14 days, there's also the antisocial behaviour ground, which is a comprehensive ground written into all model agreements. And the contract holder here can be held responsible for the behaviour of anyone else who visits or lives in or visits the dwelling. And if it's deemed that there is a breach of contract here, the landlord can serve possession notice and commence court proceedings on the same day, and the court would make an order if they considered it reasonable in circumstances. So, as we've referred to earlier, I've embarked on setting up some guidance notes to sort of complement what the Welsh Government's doing and to help our members get to grapple with the new legislation, and they're now available on the CLA website in the advice section. It's my session. Thank you.
Thank you very much, Helen. That's really interesting. And yes, I think just to reiterate, sorry, Helen, you are finished, are you?
I am. I'm just trying to stop sharing the screen now.
Yeah, no worries. I'll keep talking then. Don't worry at all. So just to reiterate what Helen has just said, those guiding notes are available on the CLA website. So please do have a look at those, because we spent a lot of time working on what the guidance, should look like. We've discussed these with colleagues and members, and hopefully they will be very helpful for you all. So thank you so much for submitting questions either in the chat bar or the Q&A bar. I think that, Simon, a number of these are directed at you, and we've slightly run over time, but that's absolutely fine, because it means that my session at the end is going to be much easier in terms of summing up, because a lot of the issues I might have raised have already been picked up in the questions. So if I can, without further ado, please go to the first question, which is from David Lewis from West Wales. And David's question is, what are the lesser requirements under a service occupancy? Is there a separate model document, or is it a modified standard contract? I think, Simon, that's probably one for you.
Yeah, absolutely. It's I have unmuted. Yeah, I have. Good. It's we haven't got a specific model contract for a service occupancy, but you would be able to very easily adapt the periodic standard contract. Essentially, it's the notice period not having to be 6 months. So I would base it on the model written statement for a periodic standard contract. Okay.
Thank you, Simon. David, if there's any other queries on that, I know will come back to us in due course, and we can follow that up for you. A question from Ian Howell, again from the David part of the CLA. Could you please clarify, I think this is for you again, Simon, can a notice for recovery of possession be served within a fixed term tenancy of, say, 3 years, so that landlord is fairly certain of vacant possession arising at the end of the agreed term without it rolling over into a periodic tenancy?
Right. No, you can't serve the notice that brings the tenancy to an end at the end of the fixed term as you can at the moment. So in that scenario, I would suggest you might want to instead, if certainty of possession after the 3 years is the key thing, to issue a 2.5-year fixed term and then issue the 6-month notice at that point.
Okay, fantastic. So thank you very much for that. Jonathan, you've put a note in the chat as well, but I think, Richard, it's a long question. If you've got that one in front of you, which is the clarify the point raised regarding the raising of rent once into 12 months. Have you got that one, Richard? And you are on mute, I'm afraid.
Looking at the regulations, I think Jonathan has understood it correctly, that he can continue the rolling period, but he will only be able to do it every 12 months. But I think the change will be he will have to give a 2-month notice now. So the regulations state that the landlord may vary the rent payable under a secure contract by giving the contract holder notice setting out the new rents to take effect on a date specified. The period between the day on which a notice is given to the contract holder and the specified date may not be less than 2 months, and he can't then, or you cannot then vary it for 1 year after the last date on which the new rent took effect. So you can still have a program of rent reviews, but you will need to meet those conditions unless Simon wishes to input differently.
No, that sounds fine. You can have you can put the rent up once a year, and you have to give a 2-month notice of it rather than a 1-month notice as you can at the moment.
Okay, Jonathan, thank you. Jonathan, I think I know you'll get me on chat if I've got this wrong, but I think you want us to ignore the point in the Q&A thing. So I'm going to do that unless you come back to me with respect to the Q&A version. We've got a message from Derek. Will there be an e-version from the Welsh government on the model contracts? I think the answer is yes, Simon. We've discussed this previously, but would you like to maybe tell us a bit more about what the model contract might look like in terms of its length and what needs to be in it, if that's okay?
Yeah, so the model written statements are available in downloadable formats at the moment on our website. So they're in Word versions, for example. So you should be able to download a version and use it in a common word processor. The documents, yeah, they are probably longer than your current tenancy agreements. I don't, and I kind of say that is because they do include everything. So whereas at the moment you've got grounds for eviction tucked away in schedules to the 88 Act or the 85 Act or whatever, it's all in the tenancy agreement. So it is a longer document. I say that it's probably no longer than your credit card agreement or your insurance document, and obviously it's an important thing at the end of the day. It's a lot longer than your credit card agreement because we can't produce it in tiny little fonts. It's in 12-point font, but yeah, it is. They are available in downloadable form. You can issue electronic contracts, so you can do things electronically, but you do need the contract holder's agreement to do that. So the default is paper, but you can do things electronically if you get their agreement to do so.
I mean, presumably, Simon, that would be very helpful for many tenants and landlords to understand that, because everything's moving so much towards digital now, isn't it? So I think we need to be in a place where that's normal.
Yeah, we did have a debate about, should the default be electronic or should the default be hard copy? Because of issues still with some people being digitally excluded, etc. That's why we went for the default being paper.
Sure.
But I mean, if you want to sort of get ahead of the curve, if you like, and get agreements, start doing things electronically, no reason not to do that.
Sure, I think that's something we can definitely look into. I mean, Helen, in terms of the model contract, we've obviously discussed this. I mean, we're not proposing to do a CLA version of the model contract, but I think from our understanding, Helen, if I'm right, we will do probably a short guidance notes or something that will help our landlords complete the model contract. Is that our approach?
Yes, we can certainly give that a go and try and flag up the key issues. Just something to help with the process. But with all these things, with all tenancy agreements, when I look at my experience with agricultural tenancies as well, the more that the parties can just put a little bit of thought in at the outset to the terms that they want to see in their agreement, then the more one avoids, hopefully, disagreements and misunderstandings, etc., with later on. So it's really worth that bit of extra effort at the outset.
And I think, Helen, you've absolutely hit the nail on the head in terms of that point about where there are disagreements. If you can absolutely, and I'm sorry if I'm stating the obvious, but if you can absolutely avoid going down the court route or the legal route, it will be so much easier, won't it? We've got numerous examples, haven't we, where it's gone so far and it's purely down the legal route. And one, it gets expensive. Two, it's very challenging and can cause a lot of issues, can't it? Particularly with tenants that may well be living in the same village as the landlord. It's just ideally to be avoided, isn't it? Okay, thank you for, sorry, Helen, do you want to come back on that?
No, I can only agree with you there. Yeah.
Yeah, brilliant. I'm going to go back to the questions. So we've got anonymous attendees. Simon, is it not possible to serve a Section 173 within the 3-year fixed term tenancy? Can you see that one on the open questions?
Yeah, no, you can't serve it during the fixed term period. You would have to wait until the fixed term has expired and then issue the notice. That's why I was saying, there may well be a change of practice here in terms of, instead of issuing a 3-year fixed term, essentially you get the same result by issuing a 2.5-year fixed term and then a 6-month notice to end the contract at the 3-year point.
Thank you, Simon. I'm just looking at the next question from Rachel Chappell. Thank you, Rachel, for joining us. The point about EPCs, which I know is another question that's been picked up in the answered bit. Is there any more to add on that, Simon? Because I appreciate the EPC is UK Gov, and we've been undertaking significant lobbying on behalf of our members in relation to bringing properties up to a C. We fully support the need to improve energy efficiency to address climate change. We're fully on board with that. However, when you look at what that's going to actually cost, it's an enormous amount, and the unintended consequences of some of that activity is that houses are leaving the private rented market and going to second homes or elsewhere, and that's another issue, but it means there's less properties available. Anything else to add on that one, Simon, from Rachel?
Not really, I'm afraid. I mean, it is just one of those areas of policy that is not devolved to the Welsh government. So, I mean, the whole EPC thing is driven. I think it's the BEIS department, BEIS, who are responsible for that in the UK.
Yeah.
Or best is you continue to lobby in the way you are, Nigel. Sorry.
No, we definitely are talking to UK government. We've also spoken to the minister responsible. I know you can't comment on ministerial conversations, Simon. I appreciate that, but we have spoken to the minister about this for our members' understanding, and we have expressed our absolute frustration with this particular issue. And as I said earlier, those unintended consequences where we're seeing large numbers of property leaving the rental market, which in some ways might be a good or positive thing, but in other ways they do leave that particular market. So I think we'll pick that up elsewhere, or we may well spend the rest of the session talking about EPCs. But thank you, Rachel, for that, and our other colleague who put a question in that's now been answered. A question from Anne: when will we get that information? I'm looking at the panel, but I think this is around the EPC stuff again, Simon. Got that right?
Right. I don't know what information that's referring to.
Do you want to come back to us, Al? I know you've got another question about help given to rural private landlords to raise EPC from E to C. I think the answer is that, as Simon says there, it's UK Gov anyway. What I suggest, Anne, is we have a conversation with you offline and we can talk about what we're doing, because I don't think we can quite answer this now, because I don't think there is any help, and it is a big issue that is slightly outside the scope of the speakers. Unless, Richard, you've got anything you might want to add on that particular issue, I think we'll pick that up offline.
I think you're quite correct, and I know you're lobbying very, very hard on that point. And I think really from our understanding, and it's terrible because we all want to improve things, but you're better off looking at the exceptions rather than the funding to carry it out. I think the exceptions in most of our cases in the rural areas, the cost of the works being an exception is perhaps the way forward rather than complying, which isn't really what we'd like to do. Yeah, sure. Okay, conscious of time, there's lots of other questions to answer. So question from Emma Story. Thank you, Emma. You've got a question there about 12 months fixed term EST starting 1st of April with deposits held. That's literally just disappeared. I think that's probably been answered then, has it?
Sorry, Nigel. Yeah, I jumped in and typed an answer to that one. No, you shouldn't.
Not to worry. Don't worry, Simon. You beat me to it. Not to worry. I'm going to go back. Sorry, sorry, Simon. You could, if we're live, you could have nudged me, couldn't you? But we're doing our best on the webinar, aren't we? So I'm just going to go back to Ian's question, which has not been answered. Agents are used to using a memorandum of agreement for changes to tenancy contracts. Is it necessary to reissue a whole written statement when only adjusting the rent, for example? That's either you, Simon, or Richard, possibly.
No, you don't have to issue a whole written statement if you're adjusting the rent. If you're adjusting other things, you might need just to send, you could just send that revised term or the whole written statement. I suppose it depends how much is changing.
Okay, fantastic. So I can't see any more questions in the open section. We are due to finish around 5:15, so we've got a little bit of time left. What I'd like to do, because people have joined us, is just go back onto some of the answered questions and see if there's anything else that we need to pick up around that. What I hope that will do is give attendees a chance to put any further questions in the box. Do stay with us to the end of the seminar, unless you, of course, you do need to go. But I know that just the point, Simon, you have come back around the question from an anonymous attendee around a farm worker and wife occupied a proportion of a farmhouse as part of the husband's employment for 30+ years. Is there anything else that you might want to say around that, Simon?
I think the key point really is what is the tenancy the person's got at the moment? Is it, I mean, some tenancies are converting, not all tenancies are converting. So if it was an old Rent Act tenancy, then it wouldn't be converting. But if it's an assured agricultural occupancy, it would convert to, I think that's going to be a periodic standard contract without the section 173 notice, so that they've got the security of 10-year equivalent to what they'd have under an AAO.
Sure.
But a lot depends on individual circumstances here.
Of course, yeah. That's the key thing, isn't it? What is the individual agreement that they've got? Often it may not be written down, it might be historic, it might be, you know, in the bottom of a drawer or something, they just don't know. So it's about looking in the detail, isn't it, really, to understand what that could be?
Yeah.
Yeah. Helen, have you got anything to say around the, you know, I know you mentioned about the agricultural tenancies earlier. Any sort of thoughts around where we are on those at the moment and where things might go going forward?
Sorry, you're talking about actually agricultural tenancies rather than residential?
Yeah, sure, because that will be of interest to many of our attendees today.
In Wales, no, we haven't.
Sure.
We haven't had an update in recent times as to the changes being implemented. But as I understand, they're going to follow in the main what England has done. But no, at the moment, I don't know. There's been no update. Sorry.
Simon, is that in your remit or?
I'm afraid I'm only residential tenancies, I'm afraid, so that would have to go to my colleagues in the agriculture department, sorry.
Sure, thank you. I'm just looking at my colleagues in Wales. I wonder if that's something we could pick up with your colleagues, Simon, and just provide an update. I think would be useful for a number of our members who will be on this call.
I'm happy to help find a contact if I can, if you haven't got one.
That would be absolutely brilliant. So bear with me while I just go back to the open questions. So Emma, you've come back on that one, Simon. Have you got that question in front of you? Minimum notice an occupier has to give.
The minimum notice an occupier has to give is a 4-week notice for the occupier to end the contract.
Okay. Thank you very much. Thank you. That is great. Another question from Ian. Anything else to add on to that, Simon? Well,
sorry, I'll just say in relation to Emma's question. Sorry, they obviously
sure, no
they can't give a notice to end a fixed term. They can only end the fixed term will only end for them as it does for the landlord at the end of the fixed term. The 4-week notice is when it's gone periodic.
Okay, fantastic. Thank you. Another one from David Lewis. Thank you, Simon, for the response. What is the minimum notice period permitted for a service occupancy? You've put a link on there, Simon, which again is helpful, but anything else to add on that?
No, just say it's 2 months. So basically, if it's not, but for all the periodic standard contracts which aren't subject to the 6-month notice, it's a 2-month notice.
Okay, fantastic. Thank you. I'm just again looking at the questions. I know that Emily will be staring at me if I've missed something, but I don't think we've missed any of the questions. on the open section. Just scrolling through those. If you have got any others, we've got a few moments left. Please do. Emily, do come in.
Hi, everybody. I've just noticed that a question come from David Lewis as well, is when can we expect guidance on transfers from assured and regulated tenancies?
Assureds at the moment, I mean, I suppose the tenancy most people will have is an assured short-hold tenancy. So the guidance on doing a conversion essentially uses the is based on the periodic standard contract, which is the nearest equivalent. What you really need to do is look at the model contract that's closest to your current type of contract. So if it's an AST, it's periodic. Look at the periodic model written statement contract. Identify what are the fundamental terms in that model written statement, because it's only those fundamental terms that will overwrite your existing terms in the contract. So I always think of it as, because the supplementary terms can be varied either way, you can kind of take as read anything that would be a supplementary term in your existing contract comes across as part of the conversion, because it's, you know, it's assumed, if you like, it was negotiated at the outset and that's what was agreed. But the fundamental terms, they are the legal minimum. So look at the fundamental terms. If they conflict with your existing agreement, then they go in your new written statement. If they anything else, if it doesn't conflict with a fundamental term, it survives the conversion process.
Thank you, Simon. Unless I've missed something, I think that is all of the questions. Emily's going to hopefully nod at me. I don't think we've missed anything particularly on there. Literally last chance, if you have got any questions, to post them either on the chat or the Q&A button. Otherwise, I think that is probably close to being the end of the session. Okay, I think my overriding sense, Simon, is that you know, there's obviously a lot to be done now in the run up to when the implementation takes place. There's a lot of detail in there. We've got some guidance notes that the CLA has replied. I've just had a couple of messages from a few members around saying it is rather confusing. So, I mean, in a sense, Simon, maybe I'll ask you to answer that. For those members that are being quite open and honest and saying, I am actually really confused about what I should be doing, what would be your maybe one or two quick things that they could do in order to get to grips with that?
What I would say is, please do go and have a look at the website. There's a lot of information up there. I get it was almost too much information, I suppose some people might say. The key documents up there, I would say, are the model written statements. Have a look at those. Have a look at the guidance for landlords on fitness for human habitation. Have a look at the guidance on converting existing contracts. I think those are the key things really. It's not. I know it's not as complicated as it sounds, but unfortunately, because we are talking a lot of new terminology, etc., it is all. You know, I get that it's a bit daunting if you're sort of just look at that model written statement. But as I say, just focus on the fundamental terms. Also, don't forget, you will need to issue that written tenancy agreement for all contracts, new contracts, from the 15th of July. So do make sure you've got your new contract ready to go. You have got 6 months to do the converted version. So, you know, don't panic about too much about the conversion. You've got 6 months to get that sorted, but you know, at least make sure you've got your new written statement that you're going to issue for new tenancies from the 15th.
Thank you, Simon. We've just got one more question, and I think we do need to stop, from Ian Howell. Thank you, Ian. Where guarantors are used for a tenancy in a contract and a joint tenant vacates, will a new written statement be required?
I'm pretty sure the answer to that is no, but if you want to drop us a line on that, I'll confirm. But sorry, that's a bit of a technical one. I'd have to look at the act.
Not to worry, Simon. We'll pick that up offline. We are close to the closing date. I can't see any other questions, so I think we will finish there. I've just got one thing to slightly put the panelists on the spot, but I'm sure you'll be absolutely fine. If there was one piece of advice you would give to our members over the next couple of months, what would that be? You can be as short or as witty as you like, but so I'll give you literally 2 minutes to think about what that might be. Emily, in very, very short summary of what else are we doing on housing to support our members more generally, because there's things outside the guidance here, but a very, very brief summary of what else we're going to be doing for members over the next couple of months, please.
Thank you, Nigel. So I can imagine a lot of you are aware of the housing issues we have with second homes and holiday lets and the various consultations that we have responded to. We have responded to the recent consultation on the criteria days being increased to 182 days actual let for holiday lets. So our work along with the Wales Tourism Alliance, we are responding, we are in talks with Welsh Government, and that is one that we know that many of our members have concerns over. But going forward, we have a number of housing events that we are staging, and we'll have a large presence then, especially on housing then at the Royal Welsh Show and also at the smallholders event next month at the Royal Welsh Showground. Members are always welcome to approach myself with any concerns going forward, and would love to hear from you.
That's a great elevator pitch, Emily. Thank you very much for that. I'm not going to do a long summary. I think we can finish on time. I think for me, though, what I've really picked out from this session is, and again, thank you, Simon, for your frankness and trying to answer all the questions there. I mean, arguably, I think Welsh Government would argue it's just going to be a simple, fairer system for tenants and landlords, bringing everybody into this general model standard contract and a written statement. Lots of detail around that, but in theory, I think the landscape going forward is really around having everybody pretty much on the same page best that we can, which arguably in many ways may well be a good way forward, but members will make their own minds up around that. Loads of technical detail. Have a look on the Welsh Gov website. Helen, you've kindly pulled together our guidance notes, and we've got colleagues in the office that can help with anything that is technical, or if you'd like a view on it. In terms of some of the risks, Simon, if I can be honest, breach of contracts, things do go wrong, sadly. Most of our landlords will be absolutely doing their best to maintain that relationship, but sometimes things do go wrong. And I guess a worry for some of ours might be, the point about the human rights defence, and I think everybody would understand where that's coming from. But if things start to go down the road of heading up in the courts, it can take forever and ever. It can be very expensive. So if possible, try and resolve things best you can before you start to go down that particular route. I know, Richard, you were talking a lot about some of the issues that some of your clients will face. You talked about the improvements required, electrical smoke alarms. We've all talked about the EPCs and how that's going to be a really challenging issue. So I think there's one to bear our mind with on there. And last but not least, Helen, I'll say it again, thank you so much for your help on producing the guidance notes, and colleagues and members, do please have a look at those. So just to finish off then, I will give our speakers the final word, because thank you so much for attending, and also thank you for all of our members for attending this event. But what is the one piece of advice you would give to members over the next couple of months? Start with you, Simon. Short and sweet is fine.
Okay. Well, I'm a civil servant, so I'm not allowed to be witty, Nigel. All I would say is, keep the faith. It will. There is a hump that we've got to get over. But when we're on the other side of it, it will be easier, because the law will be much clearer for everyone than it is at the moment. You won't have to go away and look at case law, etc. It will all be in the contracts, and it should be much easier to get advice from organisations as well, because everyone's going to be using the same terminology.
Richard, you're not a civil servant, so you are allowed to be witty or frank. You're on mute, sorry.
He goes, it's a shame I'm not witty, Nigel. So just quick, I think there's a very, very short window of opportunity for people to change things before this comes out, if that suits them. And On my attempt at being witty, I had a client, a good CLA member, who asked me when I told them I was speaking on this. Their comments to Simon was, with all the Welsh Government's legislation for landlords that's coming, with Rent for Smart Wales and exams, is there any proposals for there to be exams and legislation for tenants as well as landlords?
Excellent, thank you. Simon will pick that up again, no doubt. And Helen,
I
last but
I
not
think
least.
I'll have to regard
Go on
that
then.
as a rhetorical question, I think. Sorry.
Fantastic, thank you. Helen, last but certainly not least, what's your one piece of advice for attendees today?
Absolutely not to panic. Pull out your existing agreements. Go to the Welsh website, look at our guidance notes. The information is there. But yeah, address it now, sooner rather than later. And then there'll be less of a panic.
Brilliant. Thank you, Helen. We're a couple of minutes over, but I hope that was a useful session for everybody. Thank you very much indeed. Diolch yn fawr I chi, and we will see you all again shortly. Thank you very much.
Thanks. Goodbye.